So, Michelle, financial processes in mediation is a hot topic at the moment for clients. How do you approach it?
So, Lindsay, we obviously both deal with financial mediations. We would have met both parties for their initial sort of assessment meetings first. So what I explain to clients in that meeting is, in order for us to have informed discussions about the finances, then it's really important that there be a disclosure of the parties' finances. I tend to suggest to most people that we complete a Form E, or they complete the Form E. The Form E is the document that the court would expect parties to complete if they were going through court proceedings, as you know. I explain to clients, of course, that the reason they're coming to mediation is that they want to avoid court proceedings, but it's still a really handy document to have, to get all of the information in one place. Do you do the same? Do you suggest Form Es?
Yeah, I do the same. I know previously there was a shortened version with mediation, but I think the more information we have as mediators, the fuller the options are that we can provide to the clients. And so I think Forms E are just so helpful. And I know clients can sometimes find them quite a laborious task to complete, but they are so helpful because they ask all sorts of questions about clients' financial circumstances, and it just gives us an opportunity to identify what the issues are, what we need to think about in terms of other support for the clients and options and ideas for them to make their own decisions.
I mean, as both you and I are practicing family lawyers as well, so, you know, we are aware of the sort of the roundabout advice that both parties are likely to be given, and also the procedures. So it's really helpful for us, isn't it, when we refer our own clients to mediation, to have that Form E come back, so that we can see what each party's finances are and we can advise our own clients on it. It's really important that we can then offer both parties' lawyers that information too.
Definitely.
I was going to ask you actually, Lindsay, about the supporting documentation, because as you work through the Form E, it asks you for supporting documentation, so bank statements, things like that. I do have quite a few clients say to me, Michelle, we know what each other's got. We don't necessarily need to trawl through each other's bank statements. Do we need to give you them? From my point of view, my role as a mediator is not for me to go through them anyway. So, you know, I'm there to manage the process, but if both clients say to me, Michelle, we don't need to see each other's documents in support, I tend to say to them, well, that's a matter for them.
Yeah, I agree. I agree. I think we're impartial as mediators. We're not there to provide advice, and we're there to provide an environment for people to be able to openly share their ideas and thoughts and provide their financial information. And I think it's so helpful in mediation for us to have a discussion together to say, where are you coming from with this? Do you have a good idea about each other's finances, or are you coming at it quite out of the dark? Do you need to know a lot more about each other's financial circumstances? And so I think it's good that we share the same approach, obviously working together anyway, but we obviously are flexible with clients, and we want them to tell us where they are on the same page, on a different page with their financial information for one another. Do we need to look at Forms E? Do we have supporting documentation? But at the end of the day, it may be a decision for them to take with their solicitors as to what they feel is right for them. And that's when we would suggest take advice from a solicitor if you want to.
Yeah, that's another benefit of mediation, isn't it? It's their process. They can deal with that as they want. And as mediators, or lawyer mediators, we'll just give the information and they can make that decision.
Yeah, definitely. So I think we're the same in that sense, in that we're flexible with clients, and we'll meet with them with their initial intakes, discuss what the issues are with them, identify where we might be able to assist with those discussions. And it's a case of discussing with the clients at that point, what sort of disclosure are we looking at, what's going to be most helpful for them essentially in that intake session.
Yeah, I think quite a few clients actually ask me about that financial disclosure and say, you know, if I give it to you, do you have to share it with the other person? So I often have to remind clients that actually my role is completely impartial. Anything that you share with me, I need to share with the other person. Also, I have to remind clients quite often that the financial disclosure that they provide isn't confidential, unlike the discussions that we have, of course. and that the financial disclosure is factual. So they've got a duty to provide each other with that anyway.
Yeah.
And that can be used in court proceedings, for example, if that's where the parties sadly might end up if mediation breaks down.
So when we're going through the mediation process, we're having discussions with our clients about ideas, proposals, suggestions about how they might want to resolve matters. And you were talking earlier on about financial information being open, as we call it as mediators, and that can be presented to court if they end up going down the court route. But there's a difference, as you were saying earlier, about the discussions that we have in mediation, and that they are confidential, private, they're closed between us, otherwise known as legally privileged or without prejudice. Do you want to talk a bit more about that?
Yeah, I think it actually, that's, a huge benefit of coming to mediation, isn't it? You can feel that you can come to mediation, make proposals, have discussions, and not feel actually that what you're discussing and suggesting at this stage is going to be used against you, and you're not bound by it. Because you can come to mediation and the costs are going to be significantly less than if you're going to proceed through lawyers and through court. So, you may be of the view, look, if we settle at mediation, which is going to be done, a lot quicker and a lot more cost effectively, then I might settle for X, Y, and Z. However, if we go to court, I then need to factor in the time that it's going to take, the stress that it's going to put upon me and the family, the money that it's going to cost. So I may not then settle for X, Y, and Z. I'm probably going to be looking for a little bit more. So it gives clients that option really, and that freedom to come and discuss with us openly, but bearing in mind that it stays between these four walls, of course, with regards to discussions. But that leads on that clients will say, well, if it's all privileged and we can't rely on it, what happens next? So we would put that within a summary, which too would remain confidential. And then that can be taken to a lawyer to have it drawn up into a binding document, of course. So the time that they spend at mediation to discuss those proposals is not wasted.
Sure. And I think having the opportunity in mediation to air your thoughts and ideas and proposals, etc., between us is helpful for people to be able to think, actually, I'm going to compromise here, because that is the idea of mediation, is that both parties need to compromise, otherwise that's where you are in court. But in mediation, the idea is you each give something, consider each other's proposals with an open mind. You might not agree with the other person's perspectives on things, but if you're open to listening to that, it might just open up communication and some other ideas. And with compromise, hopefully clients will make their own decisions.
And of course we'll help them and facilitate those discussions, because sometimes, well, quite often actually, I'll have clients come to mediation and they're saying the same thing, but they just haven't heard it. They haven't actively listened to what each other is saying. And if they have solicitors, they may have put it in writing, but it's not been communicated probably in the right way. And as mediators, obviously, we can rephrase, we can help clients understand where each other is coming from. We can work through with them where the court is coming from as well, being practicing family lawyers. So we can work through with clients the factors that the court take into account when they're looking at matrimonial division of finances, what the court can and can't do within matrimonial finances. So it gives the clients information that they can build their decisions around. But helping them understand where each party is coming from. And both in you and I am aware, we're quite assertive mediators in that we will make suggestions and we'll say, look, we're experienced, we've had experience with lots of different families in lots of different situations. Every single case is different. Have you thought about this? And we have discussions between the three of us. And just on that point, actually, I say the three of us, we can also bring in other professionals, of course, if it's necessary.
I think we've both done that, haven't we, fairly recently as well. And I've brought an independent financial advisor in who's been jointly instructed by the clients to be able to help them to assess their pension situation, for example. It's so helpful having a professional person supporting mediation with their own specialism. Obviously, we can't provide financial advice, and it's helpful for the clients to be able to hear from the legal perspective, legal information from us, but then also the financial advice as well. But I believe you've had other people involved in your mediations as well?
Yeah, I mean, you can have all sorts of professionals involved, really, can't you? So you can have sort of IFAs, specific pension advisors, and also, you know, other people to assist. We also deal with a lot of mediations, not just dealing with finances, but also dealing with child arrangements.
Yeah.
And we can offer child in mediation, where the children can be involved in the mediation process. I would say they're not involved in the mediation sessions that we have between the adults, but it's something that we can discover. And so professionals can be brought in that side of things as well.
Yeah.
Again, every case is different, and we'll discuss with the clients what works for them and what they need.
Absolutely.
Have you ever had solicitors sit in on mediations?
I haven't personally so far. It was a discussion about the possibility on one occasion. As a solicitor, we would love to be sat in mediation supporting our clients, but as mediators, it's so important that we do our best to be able to help the clients as really holistically as possible, because we're sat there in an environment that is promoting positive, civil, respectful communication, and it's a non-adversarial process. And sometimes people's perspectives could be that solicitors involved in mediation might add that adversarial element. And so it's generally helpful as a mediator, if we're with our clients on our own, to be able to just explore some ideas, some options that perhaps solicitors might not have necessarily advised their clients to consider. But ultimately it's down to the clients to decide what's best for them, what's best for their family as a whole, with us giving legal information about the court's approach still, obviously. Yeah. But it is a possibility to have solicitors involved if it's needed, essentially, for emotional support for the client. They can be in the same room, they can be in a different room, but it is possible. Have you had that? I
have had a solicitor involved on one of my mediations some time ago, and the reason for that was because one of the clients was particularly vulnerable. Again, when we meet with the clients initially, we give the clients the option as to how mediation might work for them. And one of the mediation processes that we can offer is shuttle mediation. So the clients are sat separately. If for whatever reason they feel that they cannot sit together. And also, you know, we assess, don't we, whether or not, depending on the level of emotion, complexity, whether the clients actually should be sat together. It depends on what everybody thinks would work best. I mean, everybody wants to achieve a result and an agreement at the end of the day. So how do we get that? In that particular case that I dealt with, where the solicitor was involved, that was a shuttle mediation, and one of the parties was particularly vulnerable, and I felt she needed that extra support and advice in order to assist her in understanding what we were talking about. And both clients agreed with that process, and as did the solicitor. What clients also need to bear in mind, of course, is that there is a fee for mediation. Sure. And if solicitors are going to be involved, they will have a fee also. So there needs to be a decision and consideration as to whether it's necessary to have a mediator's fee together with a lawyer fee. You know, parties often come to mediation to try and keep their costs down. You know, it's not always, I would say, actually, just give it a go. If you're concerned and you really want your solicitor there, I'd probably suggest in the first instance, let's see how we get on without your solicitor, because you don't have to make any decisions during the session if you don't want to. And I would always suggest that you seek independent legal advice. Sure. If you feel you need it, or I felt that anybody needed it. So I know you work in the same way. It's come with an open mind, I think, is the key for mediation. And we do that too. We keep an open mind as well. Everyone's completely different in mediation and what works for them. So it's an individual, tailored process. Exactly. Well, Lindsay, I think that's been really helpful for me. Yeah, me too. To actually chat through what we do. I mean, obviously we work together every day, see each other every day, albeit remotely sometimes. Over a cup of tea. Due to the current situation that the world finds itself in. But yeah, no, it's been extremely helpful for us, I think. And I really hope that will be helpful for people that watch. Definitely. If they've got, hopefully it answers any questions that they have, or any anxieties that they might have moving forward. But obviously you and I are always open to take any inquiries from anybody. We're we're quite approachable.
We are very much so. Telephone, email.
Yeah.
Happy to answer any questions that clients have, and looking forward to more mediation in 2022.
Yeah, it's exciting.